It is 12:59. We're going to begin 1 p.m. sharp, even though we are going to have the people trickling in. And this is going to be an interesting one. I know copyright is not one of the things that agents typically have on their minds. I personally know a number of agents who have written content and have had their content stolen or rewritten and stuff like that. So we're going to talk about that. We are going to, in fact, if we just pop here to look at the topics, we're going to talk about an interesting topic as well that came up, which was, what do I do as a landlord if I provide internet and my renter actually ends up downloading illegal content. And Graham has actually got some interesting stuff that I didn't even know about that as well, which was depending on how long they're there, you may have issues or not have issues. So that's going to be interesting to hear. So it is 1 p.m. And we're just going to get into it. Everybody can hear us, obviously, because we see people chatting there, which is awesome. Throughout this event, if you guys have some other questions that we're not going to go over, you guys can ask them in the webinar, in the chat, and we can get into them for you. And as many of you already know, my name is Otto. I'm the CEO of AgentLocator. And today we have Graham with us. Graham, do us a favor and just introduce yourself a little bit.
Hi, everyone. I'm Graham Hansa. I'm a lawyer at Wilson Liu LLP in Toronto. Our offices are downtown, but right now I'm at my house in Toronto. Probably like a lot of you on the call. Thanks so much for joining us. The three main areas that I practice in are patent law, trademark law, and copyright law. So today I'm here to talk to you about copyright, which is kind of an interesting area. It's a bit niche, but I think it does actually have some interplay with real estate agents. And so that's what I'm here to talk about today.
Yeah, absolutely. And I really appreciate you having you here, Graham. And we've chatted before and we've worked with you before, and the knowledge you have specifically in the Canadian copyright and American copyright is very much different in some sense, but at the same time, it's also kind of always compared together. So it's really good to have somebody local that helps us understand these things and helps us understand a few things. There's a few things that I know agents get into when they're listing a property. So let's say if I'm listing a property and I'm taking photos that I've taken of that property, and then if I go on Google and search for an image, let's say of a community, and I take that image and use it as one of the photos that I upload, I can get in a lot of trouble for that. So we want to make sure we're going to talk about that. So Graham, why don't I just let you kind of go through and take us through what it is that we're going to chat about and talk about, and then if we have any questions as we present, we'll pop in there and then ask you. So I don't believe we're going to need the full 45 minutes for this webinar. I think we're going to be able to get through the material fairly quickly, and let's take it away.
Sure. Thanks, Otto. And thanks again for having me. So the first thing I'll talk about really quickly is what is copyright. So copyright law, in a nutshell, allows the owner of copyright to prevent the unauthorized reproduction of all or a substantial part of an original work. What is a work? In the real estate context, it's usually going to be photos, videos, or any text content that is generated as part of, so possibly the text on a listing or marketing content that you have on your website. So if you own the copyright in that content, then you can prevent other people from using it without your authorization. Okay.
Yep.
And authorization, sometimes during this presentation, I might say the word licensing, and a license under copyright is really a permission to do something with this work. So what is it you can do with a photo? What is it you can do with text? Because you may not actually own the copyright in some of the content that you're using, but what you want is the permission to do that from the person who does own it. Okay. And there are situations where you actually want to own it. We'll get into that.
Okay.
So there are a few key areas where realtors are going to run into copyright issues, either on the receiving end of a complaint or because they want to prevent someone else from using content that they think belongs to them, or that actually does belong to them. And again, we'll talk about that because there's it's not a a super intuitive area in terms of whether something actually does belong to you or not. So
the one question that comes up quite often
yeah.
is the listing photo. So if I'm a listing agent and I take pictures of the photo of the property, one of the things that we were discussing is I don't actually own those listings. I don't own those photos myself as the agent. It's the photographer that owns the photos.
Yeah, unless you have an agreement with the photographer that says that you are going to own them, and that's not usually the case. You probably just have a license to use those photos for that purpose. So it's to use those photos to list the house or condo or whatever property it is you're listing. You don't necessarily own the copyright. And actually, just speaking in pure real estate terms here, the difference is a little bit like ownership or a lease, right? So I could be a tenant in a condo, for example, and all I have is the permission to live there for X number of months that I'm paying my rent.
Right.
But at the end of the day, the unit belongs to the landlord, right? Whereas ownership of the copyright in the photos is a bit like a house ownership type situation. And there's nothing better or worse about one or the other ways of being able to use the content. The main concern for most real estate agents is just that they can actually use the content that they think they want to use or on their listings or on their websites. Okay. So if you hire a third-party photographer, which is what most listing agents do, then most likely the photographer will retain ownership of that. And like I said, the realtor will have permission to go and reuse those images on their listings. Okay. Now, one area though, where sorry, so I should go back and essentially that situation works for most agents. Okay.
Right.
And for most type of listings. One area though where you can run into trouble is, let's say you're listing a downtown condo. You hire your usual photographer. The photographer goes through, takes photos of the unit, maybe the building, maybe even the facade outside. And then later on you decide, I'd really like a skyline photo of Toronto to include in my listing. Maybe my market for this is people who don't necessarily live in Toronto. And I think it'll be good to just give them an idea of what
perspective,
like what Toronto looks like. And maybe I even want some ground shots that show St. Lawrence Market or something. So a really tempting way to get that is to go on Google Images and type in St. Lawrence Market and pick the first photo you see. Now, that's risky, and that's where you can land yourself in trouble because you don't know who took that photo. You don't know who owns the copyright in it. And you don't know if you actually have permission to use it in the way that you're intending, which is as part of a listing. And then you're going to go and put this on a listing. It's going to be available online. You may even have other realtors who are reusing or reposting your listing. And all of a sudden, you may find yourself on the receiving end of a cease and desist letter from the person who either claims they own the copyright in that photo or actually owns the copyright in that photo. And that's a situation you want to avoid. So the easiest way to avoid that is by asking your photographer to get those images. So if possible, get original images.
Right.
A lot of times the photographer will already have that. They may have already taken their own skyline shots, especially if they're doing a lot of listing photos for other agents in the same area.
Right.
They may have taken it before for another agent, and they'll like because they retained ownership of the copyright, they're able to give it to you.
Their clients.
Right. Yeah, and really the crowd that you are least worried about getting sued by is your own service provider, because service providers aren't so your photographer is not in the business of suing real estate agents. That's their client base, right? So they don't want to go around suing people. But the there are stock image companies, and they can be very aggressive about those rights. So, because they are in the business of licensing out photos, and if people are using their photos and are paying for them, then they don't like that.
Yeah.
So if you're, let's suppose now your photographer says, look, I don't have any skyline photos of Toronto. Skylines aren't my thing. So what can you do now? You could go and you can get ones from another photographer, or you could go to a stock site and make sure it's a reputable one that you actually think has the rights that you need, that they can give to you. So
Right.
if they're just claiming to own copyright in those photos and go and license rights to you, you are paying for nothing, and you can still be on the receiving end of one of these letters, and you don't want that to be the case. So make sure it's someone reputable, and someone you trust. Okay. And make sure that the rights you're actually paying for give you what you need. So can you, for example, use them in a commercial context? So sometimes there's different price tiers from stock sites for commercial versus non-commercial use. And so that's one of the things to look into. Read the fine print, essentially, of the terms that come along with that photo.
Most of these stock websites, like iStock Photo, there's a bunch of them that we've bought photos many times from them. They'll have skylines, they'll have different things. There's also a bunch of free websites that actually offer free photos. And like Graham said, just make sure that they actually are legitimate in the sense that they aren't saying it's free, but it's really not free, because at the end of the day, it's your fault if you take a photo that you don't own the rights to and post it on your website. And similar thing goes for blog posts. When you're posting in your blog posts and you're writing content, to make sure that you're not using a photo that you don't own the rights to in a similar sense, which is kind of the answer number 2 here. And what I really also wanted to make sure, because I've seen agents do this fairly often as well, Graham, is they're very much about creating videos as well. So they're going to create a video. And I want to actually talk a little bit more about video, because videos are actually so much more dangerous in a certain sense, and I'll explain how. So they're creating videos of the property itself, which is a virtual tour, or not a virtual tour, but an actual video presentation. And then sometimes what they'll do is they're going to take photos off of the internet and kind of include them in that video itself, where they're kind of zooming in and out of those photos. And they may end up using something like 15, 16 photos that they're kind of may not have the rights to. And based on Canadian law, how is it that in the event they're found guilty in the sense that they're using unlicensed photos in a video, they're essentially paying for every single photo that's used in the video? They're not paying as one video. They have to pay for each individual photo separately?
Yeah. Okay. So what happens in Canadian copyright law, if someone infringes a copyright owner's copyright, if they go to court, they can ask the court to award what's called damages. It's essentially compensation for use of for the infringement. And normally damages are based on the actual damage that was suffered. So what was the actual loss that, say, the photographer suffered as a result of you doing that? And one proxy you can use for that is, what would the licensing fee have been between two reasonable parties negotiating at arm's length, right? But we also have this type of damages called statutory damages, and it's a range. And the copyright owner can argue, without actually proving the damages that they've suffered, they can argue what would be reasonable within that range. And the range in Canada for commercial copyright infringement is between $500 and $20,000 per work in most cases. So as you increase the number of works at stake, you increase your potential liability. So multiply by 20, and that's your upper range for statutory damages. So if there's 10, all of a sudden you're you were looking at 20,000 if it was a single work. Now you're getting to 200,000 if there's 10 of them. And so that could be 10 different photos, for example. And so it's that's a situation you really want to avoid, is if this is going to happen, you don't want it to be happening on a large volume of works. So you don't want a large number of photos at stake.
If you're doing a video, you want to do a video in full shot. If you're adding photos into that video, you want to make sure that you own the rights to the photos. I mean, essentially, we just want to make sure that we own rights to everything that we put out. Now, I'm going to ask you a question actually that we may not have discussed, and that was also like, if I am now the copyright owner, I'm the one as an agent, I wrote my blog, and this happens often, you know, and I'm going to ask a question specifically for one of the agents that actually owns a fairly large real estate group on Facebook. She does a lot of content. She's actually from Toronto. She creates some amazing content, and she constantly has agents copying her content and posting it on their websites as if it's their own content. What can she do to protect herself? So what can the agents actually do to protect their content from other people stealing it?
So if she or one of her employees has actually was the person actually writing that content,
yes.
Typically she'll be the owner of the copyright in that content, and that gives her what we call in copyright law is standing. So it means she can go to court and sue those people who are taking who are basically cribbing her content, right? And you know, a lot of times, whether you can go to court or not, it's academic, because what happens is all happens out of court in terms of letters, but
settling it.
But it, you know, the lawyer who is acting for the receiving party of one of these letters is going to take it more seriously if they think that the person who's sending them actually has standing to sue in court, because it means that, like, what is the alternative if we don't settle is this person may go to court and then can actually bring this case against us. So having standing is important, and that's where ownership comes into play. So you know, a lot of the times I would say whether you own something or just have a license to it is not that important until you're interested in enforcing. So for your realtor, if she wants to be able to enforce against these other people, she's in the best position to do that if she actually owns the copyright. And she will typically own it if she's written it herself or if one of her employees has. As soon as a freelancer or an agency writes the content for her, then the situation starts to change. The presumption is that the agency or that freelancer owns that content, and she just has a license to it, unless she has an agreement otherwise. So that's the sort of thing where if this is a problem she wants to prevent going down the road, she may want to talk to the freelancers and the agency about actually getting that copyright ownership, like ownership of the copyright assigned to her. Okay, and that's a fairly straightforward process. But again, it may come at a price premium. So,
and that's actually leading on to a question. So what is the downside of photographer owning the pictures he takes for you of your listing, or why can't we own them if we paid for them? So this is actually a question by Nadia that she posted on our chat here. And so I know we've kind of looked into this, and you found out that some more information about what photographers do when that's requested.
So, so it is possible to obtain it from the photographer. It's just something you have to negotiate. Before giving this presentation, I actually spoke to some neighbors who are realtors, and what they tell me is that photographers typically charge a premium to grant ownership. The reason you don't own it just because you paid for it is because that's what the law says, essentially. Right. And actually, it wasn't always the case that photographers were presumed to be the owners of commissioned photographs. So that changed in, I believe it was 2012, and that's because photographers didn't want to be inadvertently giving copyright ownership over photographs they'd taken. Often that prevented them from being able to go shop their photos around to other agencies, especially
right, even advertising and
or using it for portfolio purposes. So they switched the presumption, and now it's that like anyone who's a contractor, they're presumed to be the owner unless you have an agreement to the contrary. And again, in most cases, this isn't a problem because you still have the rights you need to use the photos. It's just that when you want to go and enforce, prevent other people from using those photos or that content, that's when this becomes an issue. Okay. And I would say like 90% realtors probably aren't that interested in sending cease and desist letters to other realtors for for using photos. So one area where this might come up though is if you fear that a client, like a current client, is going to decide to go with someone else, and that next realtor is going to use your photos. That's one area where you might want to be able to tell them to stop. I understand. So there's the copyright way to do that, and that would be if you have ownership, it helps. If you don't have ownership, though, I understand there are often informal processes through local real estate boards.
Yeah.
So TREB, for example, I personally am not familiar with the process, but I do understand that there is one for getting the subsequent realtor to not use the photos that you paid for. And actually, I just wanted to come back. So at the bottom of the slide we have up, it says it's Article 28 on the Canadian Real Estate Association's The Realtor Code. And it says realtors shall respect the intellectual property and other ownership rights of other realtors, boards, provincial, territorial associations, and CREA. So I'm assuming that if you do bring a complaint against another realtor, this is one of the provisions that would help you with TREB, for example.
Yeah, and I believe there's a RECO, which is Real Estate Council of Ontario, and Ontario and others as well, that you know, if you've got issues with another agent, that would be the best way to kind of handle it in that perspective. So that's great. I mean, some of the main concerns we've kind of gone over, which is agents saying, you know, I've got my copyright, I've wrote the content, somebody else is copying me, what can I do? Now, in the event, and the question was also asked, where, you know, how much could I really go after? So if I wrote that blog, if I did everything and they copied it, and you know, how would that work? Have you ever kind of looked at that case where how much would I be able to get from that agent in the event they copied my work?
So it depends. Again, it depends how much content they've taken, how many works you can start using as a multiplier.
Right.
I mean, in terms of like a negotiating position, whether what happens in court is something else altogether. It's academic in like 90% of cases, right? Because most cases end up settling before anyone goes to court. And the way it would work is so let's say you own this, you wrote the blog post yourself, and you're getting a really good following, and you know, as night follows day, someone's going to start copying it. So you or your lawyer would write a demand letter or cease and desist letter to the other side. You would tell them to take it down, and you could even ask for compensation. In most cases, the easiest thing to get is to have them take it down. And like most people who receive a letter like that will comply in my experience. Like lawyers who are in my area, we send these letters all the time because we have you know, certain types of clients where this comes up over and over and over again. Sometimes you can ask for money. If you ask for too much, though, then it starts to become a long dispute. And like, how long do you want to spend negotiating with someone?
And what is the cost of the lawyer that I have to hire to do this? And it just might not make economical sense for us to do that.
Yeah.
Because if the fees are maybe 500 to 20,000, in most cases it's going to be maybe in the lower end of that spectrum. Right, makes sense. Okay.
But I think like even you know, between $1,000 and $2,000, and sometimes what like when we send these letters for some of our clients, what they're interested in is recovering the cost essentially of having the lawyer send these out and policing.
Right.
But in most cases, people are mostly interested in just having it taken down.
Yeah,
so.
Makes sense. Yeah, and the last item that we have here is really, what if I'm a landlord or represent landlords? You know, how can I avoid copyright issues, and what really happens? Like, how does that come about where I'm getting a copyright notice as a landlord? What ends up happening?
Sure. So a lot of realtors are landlords themselves, or they represent landlords, especially in the negotiation of the agreement with the tenant. And one thing I've been seeing over the past few years is landlords getting sued in copyright infringement cases where they provide the internet service as part of the rental. They're the account holder. And then one of their tenants is torrenting pirated movies.
Right.
And the only way for the copyright owner, so say a film studio in this case, to identify the defendant in one of these cases is by an IP address, because they don't know who actually is associated with the IP address. So the way these cases work is a film studio, and one of the more common ones that you might run across is Dallas Buyers Club, for example. So there's a film studio that owns the copyright to Dallas Buyers Club. An investigative company that has special software, in most cases it's in Germany. They basically monitor the internet for anyone who is making copies of Dallas Buyers Club available as a torrent. They identify the IP address where that's available. So in this case, the landlord's IP address. And then they send a notice to Bell or Rogers or whoever the internet provider is associated with that IP address. And they say it's a notice of claimed infringement. So it says, stop infringing the copyright in our film. And they ask Rogers and Bell to forward this along to the account holder who's associated with that IP address. Okay. So again, in this case, it's our landlord. Even though it's a tenant who's actually the one using that internet connection.
Right.
A couple years later, the owner of the rights in Dallas Buyers Club goes and sues several thousand people. They don't know anyone's name, so they do it in the name of John Doe, because they don't know who these people are, and they attach a big long list of IP addresses at the end of the statement of claim, and then they get a court order against Rogers or Bell to disclose to them the identities of the account holders associated with the IP address at that time and date. Okay, so now the landlord's name as the account holder gets divulged to the plaintiff, and then the landlord gets served with a statement of claim. So the statement of claim is essentially the document that tells you you're getting sued. Okay, and now the landlord has a huge headache because they have to deal with the fact that they're getting sued, and then they call me or someone like me, and they're not usually very happy about this, and they often haven't even heard of the movie that's alleged. So maybe they don't even know what Dallas Buyers Club is, but they're getting sued for infringing it. Ultimately these cases can be resolved, but it's better to avoid them in the first place. And the easiest solution is to not provide internet. That's not always practical though. And so if the landlord is going to provide internet, then one of the ways they can protect themselves is by including a term in the rental agreement that tells the tenant not to, basically has the tenant agree not to use the internet connection for any illegal activities or infringing purposes, for example, and maybe even gets the tenant to agree to compensate the landlord if the landlord is sued for, say, copyright infringement arising out of that tenant's activities. So that's a clause that some of your customers might want to see if you're the realtor who's representing them. The other way to reduce the risk somewhat is for the landlord to monitor their emails really carefully if any of these notices actually come in. So they always come by email, and if they're very easy to ignore. Okay, so I get calls from people all the time who say, I never received the notice. Sometimes they actually can't even find them after the fact, but sometimes they can, and they're like, I never read this, it looks like spam to me. So just be aware of this issue, monitor your email, because if you act quickly and get the tenant to stop doing that, that can really reduce the odds of getting sued later on. In all the cases I've been involved with, the copyright owner even says in the statement of claim itself that they only they only sue people who receive 2 of these notices, and they space them apart, usually by 7 days or more. So if you're able to stop your tenant from torrenting right away, you can really, you're taken out of that, like the pool of potential defendants, and they won't.
Lawsuits, right?
Yeah, and they typically won't sue you. And sometimes the notice itself even says if you remove the work within 7 days, then you won't be sued.
So the important part here is also just to mention for even ourselves and my kids and our kids, you know, so on and so forth, that might be doing this. If you're doing this on a continuous basis, if you know you do it once and you kind of, you know, it goes away, it's not an issue. It doesn't become an issue more than likely. But if you continue doing it and you continue using your service like this, where you're downloading these videos, it really starts to become an issue, and then you could be part of this lawsuit that ends up coming 2-3 years down the road that you might not even expect. Okay.
Yeah, and at last count, there were about 20 of these lawsuits in Canada, and some of them have several thousand or more defendants listed in them. So there's actually like pretty big numbers in terms of how many people are facing one of these. And so one group I hear from is landlords, and that's an issue.
Yeah, they're being accused of it. Yeah. So then how much is one of these claims? I mean, if from what you've seen so far, how much are they? How much does one individual homeowner have to pay? Approximate, you don't have to be exact.
So usually this is considered non-commercial infringement, and I talked earlier about statutory damages. So in a commercial context, it's between $500 and $20,000.
Right.
In the non-commercial context, it's a lot lower. So it's $200 to $5,000. Okay. So that sort of sets like the range of where the real risk is. I happen to know that the lawyer who brings most of these, in some cases, will consider, will argue that a landlord is actually in a commercial context, because they're operating a business essentially by renting out their property. And even though I think legally, like, a landlord is in a better position than most of the defendants, at the end of the day, you're negotiating with this person, and their theory is that a landlord is actually at like a higher level of liability. So so it's a bit of a tricky situation, but I mean, like, generally speaking, it's probably $5,000 or less of risk. So like, again, it's just one risk to consider. It doesn't mean you should never offer like internet to your tenants. And again, like, especially if you have multiple tenants living in the same place, it may not make sense for each of them to have their own internet connection.
Of course.
Right?
Yeah, that makes sense.
So it's just, you have to weigh that against the risk of this happening. Okay.
Makes sense. Yeah, no, that makes all sense in the world. And Graham, I really appreciate you coming on and sharing this stuff with us. You know, what I really wanted the agents to understand the potential, because we see it often where, you know, somebody uses a photo in their listings that they don't own the rights to, and then the amount of trouble they get into, it's just not worth it. So do not post photos on your website that you do not own. Do not copy other people's work that you do not own. It just creates headaches. And then if you're using a company to hire them to write the content, you should also vet that content to make sure that it's not copyright or copied. And the best way to actually do that is if you hire a company to actually write content for you, and they write a piece of content and they want to post it on your website, take a paragraph of that content and put quotes around it and Google it. You can Google that paragraph of content to find out, does it exist currently online? And if it does, it'll show you on Google that it actually exists already, and it'll tell you which website it exists on, which means that company more than likely copied the content and put it on your website. So that would be a kind of a, if you don't know the company you're dealing with, I would definitely be doing that to make sure that I'm not, you know, posting anything illegal on my website that I don't have the rights to. So I think that was actually, I have a couple of questions about blogs and images before we go. So we have I think this is Crystal. Oh, awesome. You scared me. You got Crystal on. You have a couple questions. Go ahead.
Yeah, so we actually had a client yesterday email us that she had a photographer take photos for her, and she paid, and of course the and she put those photos on her website as one of the main images. And he of course found out that she did, then asked her to take it down. Now, when it comes to the copyright and ownership, is it assumed that there's copyright? Does there need to be a contract signed indicating the usage of those photos, or what are the rights of the person buying those photos and the rights of the photographer in those stances?
So listen, lawyers always love things to be in writing, but in the real world, that's not always how it's done. You know, especially if you think of an agent who's been in business for a long time, they've probably been working with, you know, a couple of photographers that they really trust and have a relationship with. And most of the times those aren't going to be the ones who are running into problems, right? Whether they have something in writing or not. But even if you don't have something in writing, we have this concept that it's called an implied license. So if you are paying someone to take a photo for you, and they know you're a real estate agent, and they know this is a listing photo, there's generally an implied license, unless your agreement says something to the opposite, that you have a right to use the photos for the purpose that everyone was fully aware it was going to be used for. So like an easy one would be, could you put it in a listing? Most likely it would be very unreasonable to have someone pay a photographer to take photos of a house that they couldn't then use in like the listing, especially if it's an agent who's hiring the photographer. If you have something though in writing that says, here are all the things you're allowed to do with this photo, that's always a clearer, easier case to resolve. So I'm not sure I completely understand what happened here. So someone, like, is it that they left it up essentially on their website as one of their main shots?
Yeah, so there was like, it was for one of her listings, but she really liked one of the photos that he took, and so she used it as like one of the main images for the the look of her website, and he's asking her to take it down because now that's not associated with the listing that he originally took the pictures for.
I see. Yeah, so I that sounds like an area where like conflict could arise, and it's gray without. So I don't want to give advice.
They're just better off getting it in writing what I can, like what I can use these images for after the fact, right? So that there's no gray areas. It's like black and white. This is what you can do with these images after the fact.
Exactly. And I don't, you know, I don't know what the common practice is, but I assume in a lot of cases there's actually no written agreement. And everyone is kind of fine with that as long as everything works out. And then this is the sort of situation where it's like a gray area that maybe wasn't so clearly contemplated at the outset, where you can kind of see disputes coming up. But it may be something that even just a discussion with the photographer can clarify, and
or pay additional to be able to use it for that.
Exactly.
Yeah, although, I mean, I just want to mention one part before then we go. I mean, I honestly would stop using a photographer, number one, because, I mean, if I'm writing a blog post on my website and use or even use that photo as the main photo of my website, if I paid you for that work, and if you're asking me now to pay you more because I'm going to use that shot, it just the sense of this individual photographer clearly doesn't want real estate agents' work. And I think they should stop using them for sure. That's just my opinion in terms of what I would do and how it. And I would also take the photo off my website so that, you know, we may not have issues from the legal perspective.
No, for sure. And then something to do with copyright and blogs. So one of the things that I talk to clients about is, you know, people constantly on social media share different articles by the Globe and Mail, National Post, things like that. if they're taking that article, let's say, and putting it into their own words, some of the sentence structure may be similar to the original article, but they've more or less taken and that article and dumbed it down into a different format. Is that okay to do, as long as they're recognizing and including a link to the original source of the content? Or are they looking at trouble down the road should the actual author of that article find that there's certain paragraphs or sentences that they actually wrote are within that blog?
Yeah, so again, this is like, copyright has a lot of gray areas, and it's sort of a sliding scale. The closer you are to someone else's article, the riskier it gets, right?
Mhm.
I know, like, I write articles, actually, legal articles, and one of the things I read other people's articles because I want to, learn about the subject. And there are people who write very good articles. I read them, but one of the things I always try to do is I essentially compartmentalize those. I keep them separate and I write my own from scratch.
Mhm.
And that's like, especially because of the line of work I'm in, it would be really embarrassing for that to happen to me. And so obviously this is something I think about because it's my job to think about that issue. But the more you write the article yourself, the better. And it's just like a best practice. And the other part of it is sort of like, what is the value of you writing this article? And if your content sounds a lot like what's in a Globe and Mail article, what value is your website giving people? What new insights are there someone else has already written, right?
I'll give us some input on that, Crystal. Just from most of the time, we write these things from an SEO perspective, like search engine optimization.
Yep.
I want to have great content on my website that's unique. One thing that they could do is, instead of rewriting essentially what they wrote, they can give their opinion of what it is that's being written. So they can give their own opinion about, here's how I feel about this, what's happening in the current, state. Because what they typically do, Graham, is, they're going to go on an article, or let's say a newspaper website, go to the real estate section, see what's really being talked about, and then write about those things on their own website, just from a value perspective of having SEO and having unique content on the website.
Yeah.
So yeah, and then basically just giving their own opinion on that, rather than rewriting exactly how they wrote it or what their opinion of theirs is. Just give your own opinion of how you feel about that subject, and that might be just, you don't even need you got their idea from them, which is the idea of what it is that's being talked about, but give your opinion on that idea.
Yeah,
Yeah, so that's kind of like where I say, like, Globe and Mail or National Post, a lot of time the average consumer doesn't understand exactly the full article. So to dumb it down into a format that the average consumer would understand what it is actually saying, so it's kind of rewriting it, but in words that is more understandable by a larger audience.
So in copyright law, we have this expression: copyright protects the expression of the idea, not the idea itself. So certainly there's no monopoly over an idea. If a Globe and Mail article talks about, I don't know, say, what is the growth rate of, or like how many units are on the market in the past year, reusing that data and citing to that data, there's nothing wrong with that. But you really want your article to be your own way of saying it. And again, even setting legal issues aside, it just makes for better content anyway, because it's going to have your voice. So it's going to be true to the message you're trying to give your clients anyway, and it'll be better content in the long run. And the other thing that you can do is, if there is an article that you're that you want, say, your customers to read, you can include a link. That's one way to do it. And then the people who are reading it are actually going to the Globe and Mail's website instead to get the content, right? So that's a pretty safe way to do it.
Is always including the original source, and Google likes that anyway. You're including the hyperlinks.
Yeah. Awesome. Well, thank you so much, Graham. I really appreciate it. Crystal, appreciate the questions in your side as well. And we're going to end it there. This was enough value that we've recorded it as well, just so if anybody, later on is going to watch it. So I appreciate everybody's time today. For those of you that were able to join us live, we had about 20 of you on here. So thanks so much. Much appreciated. If any of you, Graham, if anybody needs to reach out to you, well, let's hope people don't need to reach out to you, but if they have to reach out to you, what's the best way to get a hold of you?
Yeah, send me an email or give me a call. Our website is wilsonlue.com, WILSONLUE.com. And my profile's on there, and you can give me a call or send me an email.
Amazing. Well,
Hopefully no one needs to call me though, because I told everyone how to avoid problems today.
You guys are the only business that I know where you're like, well, I hope you don't need my business, which is it's a tough business to be in, but when people need you, we're glad to have you. So we appreciate what it is that you guys do and appreciate the knowledge you guys are giving us here. So thank you very much, Graham. I really appreciate it again.
Thanks a lot, Edo. Thanks for having me. It's been a lot of fun.
You're most welcome. All right. Thanks, everyone. Have yourself an amazing day.
Bye.
Bye.
Bye.